Citizenship on the Go. Lesson 9. American Government. The Judicial Branch. Part 1. Interpreting the Supreme Law. This lesson explains the structure and function of one of the three branches of the U.S. government, the judicial branch. In the United States, one law is above all other laws. Another way of saying above all others is supreme. So we refer to this law as the supreme law of the land. The supreme law of the land is the Constitution. No federal, state, or local laws are permitted to go against the supreme law of the land. If anyone in U.S. government at any level tries to make a law or take an action that goes against the Constitution, they are trying to do something that is unconstitutional. Other people in the government have a responsibility to stop them. The Constitution contains many rules about what the American people, state governments, and the federal government can and cannot do. In defining the parts of government and laying down rules about the responsibilities, powers, and limits of each part, the Constitution sets up the government. The Constitution defines the U.S. government as having three branches. It defines the legislative branch as the lawmaking part of government, made up of senators, House representatives, and other people who work in Congress making federal laws. It defines the executive branch as the law enforcing part of government, made up of the president, the presidential cabinet, and millions of other people who work for federal agencies and departments to make sure the law is carried out. The third branch of government defined by the Constitution is the judicial branch. The judicial branch has the job of reviewing and explaining the law. The Constitution sets up this part of government as a court system with many levels. At the very top of the system is a court above all other courts, the Supreme Court. Civics test question. What is the supreme law of the land? What is the supreme law of the land? The Constitution. The U.S. Constitution is the supreme law of the land. Civics test question. What does the Constitution do? What does the Constitution do? Sets up the government. The Constitution sets up the government, defines the government, and protects basic rights of Americans. Each of the three branches of government set up by the Constitution has headquarters in Washington, D.C. Congress meets in the Capitol building in downtown Washington, D.C. to do the work of the legislative branch of government. The President and people in cabinet-level positions, like the Secretary of Labor and the Attorney General, meet in the White House to do the work of the executive branch of government. The 9 justices of the Supreme Court meet alongside lawyers, clerks, and other federal court officers in Washington, D.C.'s Supreme Court building to do the work of the judicial branch. There are many people in the judicial branch of government, but at the very top of the branch are just 9 Supreme Court justices. Much like the Constitution is the highest law of the land, the Supreme Court is the highest court in the United States. Civics test question. Name one branch or part of the government. Name one branch or part of the government. The judicial branch. The 3 branches of government have many parts. The courts, including the Supreme Court, are parts of the government that belong to the judicial branch. Other parts of the government include Congress in the legislative branch and the office of the president in the executive branch. So that one part of the government does not become too powerful, when the Founding Fathers were writing the Constitution in 1787, they gave each branch different legal abilities and limitations. This is called separation of powers. One power that only the judicial branch has, for instance, is the ability to declare a law unconstitutional. If the courts rule that a law passed by Congress and signed by the President goes against the Constitution, that law is canceled and cannot be enforced. Power to review laws and make an official ruling as to whether they are constitutional or unconstitutional is an important way the judicial branch is able to check or slow down the other two branches of federal government. The executive branch and the legislative branch also have ways of checking each other and of checking the judicial branch. By establishing separation of powers and specifying ways certain of those powers can be used by one branch to check the other two, the Founding Fathers who wrote the Constitution were trying to ensure that the branches could balance one another out. Because of the system of checks and balances, ideally, no one branch will ever become so powerful that it controls the whole government and takes away basic rights of Americans. Civics test question. What stops one branch of government from becoming too powerful? What stops one branch of government from becoming too powerful? Checks and balances. The system of checks and balances and the principle of separation of powers both work to stop one branch of government from becoming too powerful. The judicial branch does not have the same powers as Congress or as the president. Unlike Congress, the courts do not make new laws. Unlike the president, judges do not sign bills into law or veto bills. Instead, court justices or judges have the power to review laws, explain laws, to resolve disputes, and to decide if a law is unconstitutional. In other words, the judicial branch has the power to resolve disagreements about legal matters. When people disagree about what a law means or about how it applies to real life, the disagreement needs to be resolved in a court of law. Sometimes, disagreements that need to be resolved in court have to do with whether a law is constitutional or not. If court justices decide that a law is unconstitutional, that means that they have determined that the law goes against the Constitution and cannot legally exist. The highest court of the land, the Supreme Court, has been called on to resolve many disagreements about whether a law is constitutional or not. Sometimes decisions made by the Supreme Court have been popular with politicians and members of the American public alike. At other times, Supreme Court decisions have been very controversial and continue to be discussed and debated to this day. For example, in the 1800s and 1900s, many state and local governments, as well as many businesses throughout the country, had regulations requiring racial segregation. Americans disagreed about whether the Constitution allowed laws and rules of this type to exist. Systems of segregation were designed to sort Black people, white people, and people of other races into different categories and, in many public spaces and areas of life, to restrict them from associating with members of categories other than their own. Separating people by racial category resulted in unequal protections for Americans' basic rights, which some argued meant segregation was unconstitutional. The Supreme Court of the United States heard arguments for and against the constitutionality of specific kinds of segregation in two especially notorious cases, Plessy v. Ferguson and Brown v. Board of Education. In the case of Plessy v. Ferguson, some people argued that requiring segregation on public transportation was unconstitutional because of the 14th Amendment. The 14th Amendment to the Constitution says that no state is allowed to make laws taking away rights Americans have as citizens of the United States. In Plessy v. Ferguson, Black Americans argued that as U.S. citizens, they had the same right of access to transportation as white citizens. The state of Louisiana had made a law requiring Black passengers to ride in train cars separate from those used by white passengers. If Black passengers tried to use a whites-only car, they were subject to a penalty. Some argued, however, that the 14th Amendment made it unconstitutional for Louisiana to have this law, since it gave white citizens and Black citizens different rights. Courts in Louisiana heard the case first, but eventually the disagreement went all the way up to the highest court in the United States, the Supreme Court. Disappointingly for people campaigning to end segregation in the 1800s, the Supreme Court decided the Louisiana law did not go against the Constitution. A majority of justices of the Supreme Court who heard the Plessy v. Ferguson case said that separating people by race was not in itself an act that took away anyone's rights as a citizen. U.S. states continued to make laws enforcing segregation in many areas of public life for decades, well into the 1900s, because the Supreme Court had said that making these kinds of laws did not go against the Constitution. About 60 years after Plessy v. Ferguson, however, the Supreme Court came to a very different decision in the case of Brown v. Board of Education. This time, the Supreme Court ruled that regulations set by a city in the state of Kansas requiring segregation of students in public schools was unconstitutional. Because the Supreme Court decided that the Kansas school rules went against the Constitution, cities in all states throughout the U.S., not just in Kansas, had to stop making and enforcing regulations of that kind. In Brown v. Board of Education, some Americans argued that segregation in public schools protected white children's right to receive an education while taking away Black children's right to do the same, even though children of both races were citizens of the United States. Reviewing the evidence, all 9 justices of the Supreme Court decided that segregation in schools really did result in unequal treatment of citizens of different races, denying Black students an important basic right they were supposed to have as citizens. Because the Constitution does not allow states to make laws that take away citizens' rights, the justices of the Supreme Court said that in the field of public education, the doctrine of separate but equal has no place, and states could no longer make laws requiring separate but supposedly equal schools. Since schools would never really be equal as long as they were required to be separate, following the Supreme Court's decision, segregation in public schools was no longer allowed in the USA. Civics test question. What does the judicial branch do? What does the judicial branch do? Decides if a law goes against the Constitution. The judicial branch decides if a law goes against the Constitution. In cases where a decision about the law's constitutionality would impact the whole country, the highest court in the United States, the Supreme Court, is often the part of the judicial branch that decides if a law goes against the Constitution. More broadly, the judicial branch reviews laws, explains laws, and resolves disputes or disagreements about laws. When the Supreme Court, or any other court in the judicial branch of government, decides if a law goes against the Constitution, the justices of the court are not looking only at the part of the Constitution that was written in 1787. They are looking at the whole Constitution, which includes all the changes that have been made over the years to the supreme law of the land. Changes to the Constitution are called amendments. There have been 27 amendments added to the Constitution so far, but the first 10 have a specific name. The first 10 amendments to the Constitution are called the Bill of Rights. The Bill of Rights lists many freedoms that by law cannot be removed from people in the U.S. Several of these freedoms are mentioned in just the First Amendment. The First Amendment states that everyone living in the U.S. has the right to freedom of religion and of worship, to freedom of speech and of expression, to freedom of the press, to freedom of assembly, and to freedom to petition the government. Over the years, the judicial branch has been called on to resolve many disputes about freedoms listed in the Bill of Rights. Several notable legal disagreements that made it to the Supreme Court had to do with First Amendment rights specifically. One case about First Amendment rights that resulted in a controversial Supreme Court ruling was Texas versus Johnson. In the 1980s, a man named Gregory Johnson was arrested for burning a U.S. flag outside a political convention held in the state of Texas. At the time that Johnson burned the flag, 48 states had laws prohibiting people from destroying the U.S. banner in this way. Texas was one of those states. A Texas court sentenced Johnson to a year in prison and fined him $2,000. Johnson, however, disagreed that what he had done was illegal. It is unconstitutional for any state to make laws taking away Americans' freedom of speech or freedom of expression, and Johnson argued that burning a flag as a way of showing how he felt about an issue was an act of symbolic speech. Since he had set the flag on fire to symbolize his opinion, Johnson alleged, by burning the flag he was exercising his freedom of expression, which is protected by the First Amendment to the Constitution. Johnson petitioned the Supreme Court to review his case, and the Chief Justice agreed that the case should be heard by the highest court in the United States, since the dispute between Johnson and the state of Texas was about a constitutional issue of national relevance. After much deliberation, the Supreme Court justices ruled 5-4 in Johnson's favor. Burning an American flag, the court decided, is a form of free speech. The right of Americans to express their opinion is protected by the Constitution, even if the way they're choosing to express their opinion is by setting a venerated object on fire. Because of the Supreme Court's interpretation of the First Amendment, state governments are not allowed to make or enforce laws that prohibit Americans from exercising their freedom of expression by doing things like flag burning. This is true, according to the Supreme Court, even if most people find offensive the idea that is being expressed or the way that idea is being expressed. Civics test question. What is an amendment? What is an amendment? A change. An amendment is a change to the Constitution or an addition to the Constitution. Civics test question. What do we call the first 10 amendments to the Constitution? What do we call the first 10 amendments to the Constitution? The Bill of Rights. We call the first 10 amendments to the Constitution the Bill of Rights. Civics test question. What is one right or freedom from the First Amendment? What is one right or freedom from the First Amendment? Speech. One right mentioned in the First Amendment of the Constitution is the right to freedom of speech. Other rights in the First Amendment include freedom of religion, freedom of assembly, freedom of the press, and freedom to petition the government. Civics test question. What are two rights of everyone living in the United States? What are two rights of everyone living in the United States? Freedom of expression and freedom of speech. Everyone living in the United States has the constitutional right to freedom of expression and to freedom of speech. Other First Amendment rights for everyone in the U.S. include freedom of assembly, freedom to petition the government, and freedom of worship. A right for everyone living in the U.S. that is mentioned in the Second Amendment rather than the First is the right to bear arms.